So Tonkopani Road, Bhubaneswar is abutting which national highway? Bhubaneswar Puri. You are concerned with the no, you can take your they will obtain instruction and go with the model. Mr. Ranjan Kumar Rao for the petitioner, Mr.
No, they should put the recent I have annexed where it is
that actually judgment scares at me. If you go through that judgment, that is how I have difficulty in directing because you don't stay there. There is no engagement of public interest. Or no, you say that you don't stay there. You stay in Tonkopani Road, Bhubaneswar. After Tonkopani Road, Bhubaneswar, either at best Puri Bhubaneswar Puri highway side, I think that is 66 or whatever. So Ranjan Kumar Rao for the petitioner, Mr. AGA, Dharma AGA, for 1 and 2. You want issuance of notice or disposal? Yes, Mr. Dharma. The petitioner is agreed. The petitioner alleges. I am running counsel for the petitioner. The petitioner alleges inaction on part of the opposite party, particularly opposite parties 1 and 2, particularly opposite party number 1 is not removing encroachment from government land, thereby affecting. Cannot be directed because it's going to talk about it. Cannot be dictated. Thereby affecting the rights of the persons who are using the passage as their approach road with the respective residences, respective houses. The AGA submits that there is a remedy of approaching the authorities, public forum, for redressal of the grievances of the petition. The learned counsel for the petitioner submits that the petition may be disposed of in view of a innocuous prayer. In view of the petitioner's innocuous prayer, where the petition. But having heard the learned counsel for the petitioner and the learned AGA for the opposite parties 1 and 2, the writ petition is disposed of. कौन सीटा मूव करती है ना आउट करी directing the opposite party, particularly opposite party number 1, to consider the representation of the petitioner dated 24/4/24, along with any other earlier representation into bracket small s. Regarding the grievance of occupation of the government land, OP number 3. It is further directed that such consideration by the appropriate authorities shall be strictly in accordance with law, after giving the opportunity of hearing to all the affected parties. The petition. You do not know. See the document not wrote. See, I know. See, एपट लोक बोली इठी हाई कोर्ट आसी कर देले से एतोडा के जीव गुगुडा भूत से ताको तहसील के ने कहलो बन जाय से गला से आउट को तहसील लेथिरो से दे विल लाफ एट द हाई कोर्ट ओबियस आपण को जानथिन से गुगुडा रे कोन देखि after hearing all the affected parties. ଆପଣଙ୍କୁ ଦେବେ the petition stand disposed of ନାଇଁ ସେଟା ହେଲେ କଣ ହବ କଣ୍ଟେଣ୍ଟ ଜୁରିସଡିକ୍ସନ ସେଟା ହେଲେ ସେ there should not be an order in futility ମୁଁ ନିଜେ ଜାଣିନି କୋଉଠି କଣ ହେଇଛି ବଟ୍ ମୁଁ ଡାଇରେକ୍ସନ ଦେଇ 4 ସପ୍ତାହ ଡିସ୍ପୋଜ ଅଫ ଆପଣ ଟକପାଣ୍ଡ ରୋଡରେ ରହିକି ଗୁଡା କଥା କହୁଛନ୍ତି ହାଇକୋର୍ଟ ଜଜ୍ କୁ ତଦୁପ ମାନେ you see how difficult it was to dictate that the petitioner's right because on oath you are saying that you stay in town and you are so caring that you have left your old parents there to face the encroachment. It is clarified that the order shall not be treated to be any expression of opinion or merits of the case before any of the authorities as indicated in the
Item 7.
Yes. Yes. Yes, please. Just kindly speak to the microphone. Talk for Yes.
One is the government private institution, which is the private institution.
Yes.
Our institution is functioning long and according to them also accord the landed property record for establishment that is clear corrupted. But private school is not. Those processes take extra age of mutual land to self-village. And that is the villagers decided to that the high school is the same.
Yes.
This is also mutual. But it is excessive of the requirement that is also settling in the a group of villagers illegal to this particular institution, they can consider the institution to the governing body, they come up.
Yes. Which one? 2010 or 2019?
From the property and to allow that only government to function there.
That's
So that petition was disposed of with the direction to the collector, this side.
yes.
And the learned collector took up the matter and he has given an order on the 11th and
Yes.
So finding only here said that the Tahsildar take action as against my institution or PLA, so this is a private and so for the government system also is also that would be that's the direction that's working.
Yes.
So accordingly, one of those who have been created and accepted was there on a position, government has also action money from trading. So that is no. So now, when we are ready to tell that OPLA can so we can do that.
Yes, there is a specific provision contained in OPLA for settling of the land.
The government of Odisha will take a decision setting those type of land. Private, that document was private. But now this person who will file the first case because the collector has caused mistake of murder. Now file again a challenging this order of the collector. The second petition would be.
Yes.
There again the read is same.
So that writ petition 3895/3/23 was disposed of.
Yes.
The contempt is pending.
Yes. But now I will get it for that. So past expert there file that was disposed of expert and director was given collector pass some order. They are well not active. They are active because the court collector has said that order the estimate is set. So they take action as per law. So when that process was done, the second petition private. They are running the identical way.
No, there you are not implicated or you did not venture to. I mean, you did not appear also. You are not aware. You are saying. So let both the matters be taken up together. No, the problem is that I cannot set aside those matters. My difficulty will be that what I was discussing with Mr. Raut.
But this is the now immediate break in my law because the second petition is disposed of.
No contempt. I think there is some order in contempt. So because contempt is hanging as a Democratic sword, they are moving.
There now the collective procedure is held there.
Whoever is. So both the matters have to be taken by the and what about that pending WPC 26305 of 2020. There was pending WPC.
That is it.
Oh, 38953 disposed of 23, but pending 22 is pending. So I am directing that let the 3 matters be taken up. And you have the liberty to move the next bench. Next, civil matter by bench. No, at least today I will direct that it will be listed so that this difficulty of not knowing, because even you are not sure that what is the pending. Maybe some other council or Mr. Samir Kumar Das for the yes.
That is annexed to phase 25 under rule 5.2. That is OGL.
Okay, maybe since there are two institutions that may be confusion.
So,
No, it is not intended. It is not intended. Since there are two institutions, one is covered in OPLE, other is OGLS. It may be unintentional.
Can apply.
Yes.
Under section 5.2 of OGLS.
Okay, suppose yeah, the institution has applied under OGLS rule. There is a direction by the High Court to evict them. And then the content, disposal of the content, you carry out the High Court order. That is the grievance. Maybe what you are saying is correct. That it is not OPLE, it is OGLS. But the consequence is same. So he has the liberty to move. Yeah, because if I have done the right thing, that by me passing out of the other party will come and say that he did not have used it.
If 42 में कहीं पर friend will be, friend में कहीं
No, I say, Mr. Das, I realize that may be confusion. OPLE, OGLS, कौन उन्हें भूले क्यों? But the consequence is same. His concern is that because the order passed by the other writ petition, which he is not a party, that he said. So I am directing all the matter be listed and the petitioners will have the liberty to move the next bench. No, without seeing those orders, I can. Because in effect, I will be staying those single bench, division bench. Here means division bench and the contempt order.
The order
Would be still even single bench I can stay. Indirectly I will be staying those orders.
Court is only directed and the reading of the court order.
Contempt order का देखो. Contempt order is important. I will be proceeding the contempt order.
Contempt is more
Then notice it. So at least I have to record my finding that I have my satisfaction that I have gone through those orders. I don't have those briefs. So that's I don't have those briefs. It will be difficult because then I have to guess it. No, I don't have those briefs. Who is the encroacher? Order how does it make you move the next bench along with those two petitions. Or you should have filed a memo for all listing of all these acts pending matters. Still near. Mr. Samir Kumar Das for the petitioner. Mr. Sarma for the opposite parties. Upon other side to corner, you want a complaint city. I'm calculating better. At least in this situation, in absence of the other side, the order will be passed. Again, they will file another petition. But I can say more. Because the court has taken note of it is a government upper primary school in favor of Durgapur. When you are Durgapur upper primary school. So there may be competing claims.
No, schools have no company. The persons have some company because they are now enabled to this particular issue. That is the difficulty.
The ultimate objective is to get
Originally.
He put upon school put in, upon school put in.
They have developed that institution also. But that everything.
କାଳେ ଆପଣ ସ୍କୁଲରେ ପଢିଦେବେ ତ ସେଇଥିପାଇଁ ଗୋଟେ ଆଙ୍ଗ୍ଜାଇଟି ରହୁଛି ଆଉ ଆପଣଙ୍କ ଆଙ୍ଗ୍ଜାଇଟି କାଳେ ତାଙ୍କ ସ୍କୁଲରେ ପଢିଦେବେ ପିଲା
For private high school, ତାର କାରଣ ଏଠୁ ପାସ୍ କରି ଇଠୁ
ଏସବୁ ଲେଖା ଅଛି to restore the possession of the plots in favor of the government upper primary school Durgapur. So there is a competing level. Without reading also I could guess it. This is something like naming of school also. I think you appeared in some matters of naming of school. So ये भी से बड़ा है, वो school चाहिए. So Samir Kumar Das for the petition, Mr. Sarma for the opposite parties. This the learning council for the hard learning council for the petitioner is submitted that. Petitioner school, namely Durgapur Vidyapitha, you should have added them as petitioner. The managing committee, Durgapur Vidyapitha representative to managing committee. Representative the petitioner. Durgapur Vidyapitha, single court, at Durgapur was district Mayurbhanj, represented through their managing committee, have approached with a prayer as they are threatened of eviction pursuant to this order, sir, here, pursuant to the order passed by the coordinate bench of this court, dated 30/11/2023, disposing of WPC number 38353 of 2023. He submitted that earlier the petitioner school through its managing committee have approached this court for consideration of their grievance regarding allotment of government land which they are in occupation, and the proceeding for settlement of the government land under the provisions of OPLE/OGLS Act is still pending. Mr. Das, soon Buddha ठीक होची तो? नहीं यार, फिर also भी ना. अपना इधर fast petition. और देखो. नहीं, आपने sentence आप earlier root पढ़ो.
It's a managing committee about this sort of
Approach this court, approach the authority, appropriate authority for
consideration for agreements regarding allotment which they are
allotment of government land which they are in possession of,
and the proceeding for settlement of the government land under provision of OPLE state pending.
Other absolute. He submitted that the petitioner school through its managing committee have approached the appropriate authority for settlement of government land in their occupation, and the proceeding initiated under the provisions of OPLE/OGLS Act are still pending consideration. It is submitted that in such a scenario, the petitioner institution is facing immense difficulty as they were not parties to the earlier date petition, WPC number 38353 of 2023, and they are not aware of the order passed by this court. But in view of such submission, the matter may be listed along with WPC. So, WPC in the pending along with the pending WPC number 26305 of 2022, WPC number 38953 of 2023, disposed of from 30/11/2023. 953 ଲେଖା ହେଇଛି। ଆପଣ ଦେଖୁନାହାନ୍ତି ପେଜ 2 ରେ ଦେଖୁନାହାନ୍ତି। ଓ ଆଚ୍ଛା ଏଇଟା 38353 of 2023, disposed of on 30/11/2023 into bracket na data, and the pending C1TC number 3367 of 20. For reference, the petitioner shall have the liberty to move the appropriate assigned vacation days. The clear order is नहीं आगे उड़ा ये क्यों सिर्फ आप लोग जूनियर को चाहिए इसे क्या yes sorry
item 8
अच्छा yes
They are projected to one billion. They are to the and the situation. And they are requested to put in the work for interception of transformer. And they are put in the work and the sanction transformer using the installation transformer and the contractor, the primary contractor of the operating party 4 by 3. And they are connected to booking for the transformer because that is for taking the transformer and that is the operating party for an issue and OT and they have claim that is the parallel where we the parallel and then comfort the time 20,000. And the prisoner challenge petition are not they are not to the Indian Act and they are not to the using substitute installation for transformer and the one side line they have because they got loaded to one side line and they are looking to the worker of the contractor and the department of the operating party they are and sometimes they have indicated they have before the final.
You are Mr. Subudhi or Mr. Mahanti. आपको नाम सर मिस्टर सुबुद्धि और मिस्टर महांती सो रविनारायण महांती so Mahanti you don't dispute hooking is part of the supply so where the wear ended where the hooked wear ended in your premises do you realize that by this on what you have said you see they allow temporary hooking also but with a flat payment of flat rate for building, for Samiana, for function. You see the entire the petition you have filed, what you have narrated, you have admitted the problem. But the other part is that you move the appropriate authority because it's an adjudicatory mechanism to see the recent order of the Supreme Court also. You go to the GRF. No, I don't have jurisdiction to issue notice. Don't convert me to an electrical inspector. You see, the GRF is enough. I have power after ombudsman. I have power after ombudsman. Don't convert this forum to be a GRF. Meter reading hooking petition. I cannot direct in my order that there is a disputed. Even you admit that yes, there was hooking by the contractor who was undertaking the work. And you also admit that the hook were indicated, ended in your premises. then what can be done? So you go, is there any immediate threat of disconnection or only demand of 2 lakhs?
Already disconnected. And I can ask you, and
So you should have moved the chair. You should have. You say that electricity act provides for the appellate authority because it's a billing dispute.
No, I think not it is a proceeding on one competition or 135, then they have to go.
Why would I do it? Or खाली rule tension or tolerance. Mr. Abhinaran Mahanti, so Mr. Yes, I am disposing of.
I have also they
ଆପଣ ଦେବେ ନାଇଁ ଓକିଲ ନାମ ଦେଲେ କାଗଜ ଲେଖିକି ଦିଅ ରେକର୍ଡରେ କଣ ଟା ଦେଇ ଦିଅନ୍ତୁ yes Mr. Mahan what do you say
After so you have not any legal activity. The department of
to say that you must realize that this court cannot take a share and there is already a disconnection because of you have not fulfilled the demand. You should have approved the GRF at the earliest. And it is a industrial concern. File करना है आपको फाइल करना है तो वो मांडा मशीन को डिस्पोजल in anticipation that some case will be filed same matter was already achi everyone is under a statutory duty to dispose of the petition upon the pendency देखेला तो ऊपर करिबी not to show that yes it has been filed and pending so you file आपन के टाइम मार्क तो किछ नता है
एना तो डायरेक्ट वन प्रोटेक्शन कैपिटल के चार्ज को आसने कॉस्ट तो ये बहुत दिया रहते then
कोटा बेटर अपन सजेस्ट करो सेटा अपन बोले as a officer of the court which where he will go so that he gets immediate relief after one condition he is available yes 127 of the so Abhinaran Mahanti for the petitioner अपन लिखी दियो तो तांका रेकॉर्ड के से जाय परिले काला दे नहीं so actually for the opposite party Mr. Sharma अपन एनर्जी पे ऐसे Mr. Sharma Mr. Sharma आगे लिखो तो Mr. Sharma AGA for the opposite party 1 and 3 two अपन inspector Two, 4, 5, 6. 4, 5, 6. Inspector by Mr. Sharma. OP 1, 2, and 3, Mr. Sharma. Mr. 4, 5. The counsel for the petitioner submits that he is agreed by the order passed by. Please refer to the order. Sumati, refer. One. Demand notice का या कोड है? Demand notice challenge करने में करिए. Should not challenge the demand notice also. Notice कौन है? He is agreed by the order of notice. Date 12/4/2024 issued by OP number. ट्रीट कर लेनी मैं OP 4 से नहीं सेटा टाइपोग्राफिकल मिस्टेक DGM, DJM ହେଇଗଲା। ଆପଣ JM ପାଇଁ କହୁଛନ୍ତି ଜୁନିୟର ମ୍ୟାନେଜର, ସିଏ କହୁଛନ୍ତି GM। ଡେପୁଟି ଜୁନିୟର ମ୍ୟାନେଜର ତ କିଛି ନଥିବେ ନା। Deputy General Manager into bracket କିଏ କଣ କଲେ ବଢିଆ you should buy the deputy manager electrical ଆଉ opposite party ଲେଖନ୍ତୁ deputy manager electrical peripheral subdivision TPCODL Bhubaneswar into bracket annexure 5 alleging parallel booking from the power source supplied by the opposite party electricity so that on utility supply company electricity supply company it is a distribution public supply company. So and so appears submits that he has instructions to appear on behalf of the opposite parties कोनडा आदि देना था आदि आणि दिले नो बोलत ना चेष्टा करू आणि की तो भाई आपण नो ये appears he has instructions to appear and shall file like काय file पे करिवे instruction to appear on behalf of the opposite party electricity supply the distribution company submits that in view of the statutory provision contained in the Electricity Act 127 that is an appeal to the appellate authority ताको ना कौन designation deputy electrical inspector public any other assigned authority the petitioner should move the authority by filing appeal as per the Electricity Act 2003 जो half of the अछि केते देले हो half of the amount अछि केते देले हो
50% ଅଛି ତ 2 lakh 50
हां 50% आपण reduce कर परिबे ना statutory to reduce होगा तो I understand that is what I'm asking
not direct
हां
then the authority authority काम को
केते करे
50%
ताको सुना
7,000
नहीं Mr. Mahanti it is goodness of him that when I requested he is saying because the statutory authority to strictly speaking there can't be any discount of the statute. Move. The provision that quote कर देवे 127 1 and 2. The relevant provision is quoted here. It is submitted by the learned counsel for the petitioner that the provision is harsh to the extent that there has to be deposit of the provision of appeal is harsh to the extent that for filing of the appeal the consumer has to deposit 50% of the demanded amount and in the present case the petitioner denies the entire liability in view of the fact that he has never used any hooking mechanism to tap electricity. Rather, for construction of the electrical installations, the contractor had availed the electricity if ordered by hooking. The learned counsel for appearing for the supply company opposes the prayer for any reduction in the statutory deposit amount as prescribed in the statute. Having had the learned counsel for the parties, there being efficacious statutory remedy available under the statute, this court is not inclined to grant. The court is not inclined to entertain the petition at this stage. in its facts and circumstances. Now, I is directed that the petitioner approaches the appellate authority under section 127 of the Electricity Act, 2003 within 7 working days. The authorities shall do well to consider the same in accordance with law, along with any prayer by the petitioner for reconnection. In accordance, yes, in accordance, but in view of the hardship expressed by the petitioner to deposit the amount, this court directs that 75,000 shall be accepted as the deposit in terms of section 127 into bracket English 2 for consideration of the appeal. Such deposit shall be without prejudice to the rights and contentions of either of the parties and shall abide by the further orders passed by the appellate authority. Yes, Mr. Sharma. Disposed of. In case the petition is filed by the petitioner, the appeal is filed under section 127 of the Electricity Act within a period of 7 working days. The petition shall be considered on merits without adverting to delay, if any.
Item 9.
So, I kindly just obtain the booklet now. Yes. 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 No, but as far as electricity connection is concerned, does it impact the main statute? Either way, does it? I'm trying to understand, and that is how I'm discussing. Both of you can ask with me. It doesn't provide for any prescriptive right. Somebody having electricity, you will have a prescriptive right that like a easement or any kind of thing. Listen, now in sweltering heat, it is reaching 45. Yes, Mr. Please consider. Yes. No, the other part is that. Other part is that at times, either landlord or tenant, either of them. I'm not blaming them. They are motivated by the fact that I will get electricity. That is not a consideration as far as the civil suit is concerned.
Yes, civil suit matter. Your concept is absolutely correct in a different context. Whether
No, Mr. Rao. I appreciate your concern and everything, but that should not be sway. That should not sway the lawyer. The lawyer in you should be thinking that this kind of a situation, this kind of a heat, whether fighting for electricity at so many places. You see, you have been fighting at so many places for electricity for last about 10 years. No.
Yes, ma'am.
That clarification I think you will concede.
No, ma'am.
You see, nowhere.
He is not in possession.
Did you challenge the GRF order?
I have said.
So what happened?
Repetition is pending.
So then,
The repetition is pending.
GRF for a consumer, Mr. Rao. So now kindly listen. GRF for a consumer, the appellate authority is ombudsman, not we. This for the supplier, you are not the supplier.
No.
So can a REIT court say that GRF order is bad for supply of electricity? You see, you can get a clarification, Mr. Rao, that supply of electricity is without prejudice to any of the rights and contentions by either of the parties. Either you can claim or he or she can claim.
That is true, but that order was passed behind by that. Behind that.
GRF order, scarcity, you have not even moved the authority. You have not challenged the GRF order.
I have challenged that.
You see, the day they went there and you created disturbances for installation of electricity, that day you became aware.
No, I was not aware of the fact. I came to the knowledge.
Then you are simply getting swayed by whatever been told by the person who is instructing you.
Only that, but I'm only
You
that.
see, they have even shown that due to resistance,
Their part, not my part. If that part was passed,
then I am not going to. You see, if you allege like that, then I am not going to hear this matter. When recording that, the court is only looking at the other side.
no.
Don't do that.
I am
Mr. Rao, you are experienced enough not to say that.
actually,
Not to say that. Otherwise, instead of asking you, why did I ask Mr. Mr. Because if he says that I don't have anything as far as my rights and contentions is concerned, in the suit concerned, you see, you are trying to teach a lesson. That is not objective.
but I submitted.
You cannot stand on the way of GRF order directing for installation of electricity. This discussion, you see, this discussion is enough to dispose of the writ petition, and then the credit will go to me for disposal. Since it is a law caveat, you serve in copy.
Okay, one submission, what I intended to that statement was that you also view on the basis of the fact.
No. You are the petitioner. How I am yet to see. Look at this caveat or this counter. You see, you are under a wrong premises, Mr. Rao. You are under wrong premises. I think I am being briefed by the other side.
No.
I have read your petition. That much you can say. Yes. So your petition I have read. So stop there.
No, only one thing. I am trying. Keep that.
Sir, you saw the copy. It is you first. You whatever you want to do, you do. But your presumption that I am looking at them, I do not know even they are going to appear.
The wrong perception.
Hey, you see the wrong perception of me or you.
No.
You say that I have a wrong perception. You're looking at them. I do not know who they are.
Not that. I have said that it appears that the electricity
This is the item?
would have been given.
9.
But
No, there is a clear record. If you want, I will dictate that. If you want that, if you are insisting, I will dictate that. Mr. Rao insists. I am dictating that out. That is a clear order which remains will not be challenged before the ombudsman.
no, it is challenge before this Hon'Ble.
It cannot be. Don't reduce the High Court to a electrical inspector, GRF, ombudsman. The High Court judges are not made for that, Mr. Rao.
If the operating master
Authority passes an order, that ground is available, that is more binding on the ombudsman to decide. Anyway, that's not before me, so that is not, we don't have time. No, please don't spend academics in vacation in sweltering heat without AC, doesn't solve the problems. Mr. Ranjan Kumar Rao for the petition. This is which item?
9. I don't know.
Sambit Kumar file case.
I don't know.
आपको नहीं पावर मिस्टर ये रंजन कुमार राउत on behalf of Sambit Kumar Swami for the petition. Mr. Das, sir, your name? Mr. P.K. Raut, AG. For opposite party number, it's a Devaranjan Rai whatever. For Mr. Das, AG for the OP number 5. Mr. Mishra, Sambit Kumar Mishra, Senior Counsel, instructed by Mr. Vishwajit Patnaik for the caveator OP number 2. OP number 2. The learned counsel for the caveator intending caveator oblique OP number 2 submits that learned senior counsel submits that the caveat has been filed. Caveat number 572 of 2024 and submits that a copy may be served on him. Copy solve for the discharge. Copy solve for the non-discharging counsel according to the caveat slash discharge. Copy has to be a order like you do. All takoda separate order. What is this habit? I don't understand. If अरे आपण वेदना तो सुनिया पड़ेगा ना नहीं
हेडेड बना कोई सेटा ऑब्जेक्ट कैसे लागी कर ऑलरेडी
ये छाड़ो तो है वो कोई नहीं कैसे लागी चुगली कोई नहीं ऐसे कैसे लागी चुगली व्हाट इज द स्टेट सॉल्यूशन the lauded counsel for the petitioner submits that the caveat has been attached to another case which is a irrelevant submission in as much as this court has not directed that the caveat has been lost upon you are disturbing sir you court actually is लागी चुगली I recorded his submission so then the full submission court what is this sort of behavior I don't understand you are getting jittery I don't understand I have not passed any order against you did I pass any order against you then why you are dictating obviously you have to finish the board and not dictate the order why would you say sorry I don't understand I don't like this no I am absolutely sir I am not taking up this matter even I can direct that you are saying that I am for the other side you said that in so many words Mr. Rao you said you can see the YouTube this is a live recording just the play
I have said that
why you are saying all these things I don't understand it is in a normal court proceeding
because of my tax submission
no I am not at a longer you see which observation I have made against you sorry please doesn't matter sir doesn't matter did I dictate if I have dictated please correct me
and
that you see your submission is that you have filed a caveat you are yes filed a caveat maybe so GRF also I said it is not maintainable GRF order so did I dictate that but that's a matter of interaction yes what do you want Mr. Sarao do you take order from a biased court or you want a before another no you said sir you are going on you are not only saying you are going on and if you interrupt if I stop you then you are taking exception to that you not have patience to listen to the order then you point out that which part of the order is against you so that at least I will be conscious that I am unable to dictate the order I simply recorded his submission it is submitted by Mr. Rao and counsel for the petitioner that most probably the caveat petition has not been filed. Here you should have started interrupting because even I am on the track. After I record his submission, you have noticed it. I am really sorry that sir I have to tell I don't know because I can't hold my hands here. Otherwise I would have stood up and folded my hands. Please don't do. Please I also apologize. Other move photo. Case रे किसी नहीं merit नहीं पाठवा नहीं. We are just going on. मुझे कुछ जो discourse लोग ची वो बहुत विद्वान का था भी नहीं. Simply ମୁଁ procedural ଲେଖୁଛି ଆପଣ appeal କରୁଛନ୍ତି ତାଙ୍କ submission ନେଇଆ ତା ଭିତରେ ଆମର we are just spending time କଣ ଲେଖିଲେ The counsel for the petitioner submit that caveat could have been filed in another case. However, he shall serve a copy of this petition on the learned instructing counsel. Appealing for the opinion of so and so. Yes, next what do you want? Problem because you say that the caveat is not filed, I cannot direct service of copy. Okay, because I don't want to become a laughing stock. One line I will say that caveat is not filed. Second line direct that copy be served. So system can let the copy be served. I can certify caveat is discharged in that, but copy is served. जो प्रिजम्पशन नहीं कि जज खराब होउछंती जज भूल भागी ले आपण कहीं सुडा कहउछंती एटा बंद अछि ना तो बंद करछन petition page copy of the petition is served on the upon nada district Portland third council instructing council appeal for the no that will take notice whenever the notice is issued. Upon I don't have jurisdiction. Sir, can you see the nature of prayer? When did you pass out, sir? Just kindly go through the page 9 of your petition. Just read it. Can you speak to the microphone? Can you speak? Upon upur ko rahi. Abe tolong kar.
The facts and circumstances stated above, it is therefore must consider that the Tamil Court may successfully teach to admit the application issue only to permit upon the opposing party so far as to provide a proper inquiry shall be conducted regarding illegally and irregular in proceedings.
Yes, OGA never write short form. Today we I have to attend Justice R.C. Patnaik Memorial function we are holding every May 30th. Vacation. He used to throw the fight. There was a fish caliber, quickest. I didn't have the opportunity to appear with him, but I have heard. He passed away when I was doing my masters. Never write in short form. Then whatever you have submitted now, regarding you not being disqualified, not being qualified, not being selected, why you have written? You have made a general prayer of inquiry. CPI. So being an athlete, you have the local standing to file a petition. That is one part. So you should have challenged that. You should have challenged your non-selection. There has to be a pleading. You see that you are supporting it with an affidavit also. And in the petition where you have written that you have not been selected. Yes, Mr. Malik, in vacation we should not waste time. Others are waiting. No, but you should have made a prayer before a court. I am not supposed to ask you that where is your prayer, what is your concern, how you are affected, why you are agreed. ଆପଣ move କରିପାରନ୍ତି ଚାହିଁଲେ after vacation move କରିବେ sir make amendment prayer amend କରନ୍ତୁ pleading ଆଣନ୍ତୁ do that ଆପଣ ଯାଉନାହାନ୍ତି ସାର୍ ସିନିୟର ଚେମ୍ବର ଯାଉନାହାନ୍ତି ପଢନ୍ତୁ ପିଟିସନ ପଢନ୍ତୁ कौन एसेंशियल कौन रहेगा प्रीडिंग्स पढ़ाई पढ़िथिले ना नहीं कॉलेज में प्रीडिंग्स से कौन रहेगा था कौन अच्छी ना नहीं से प्रेयर में कौन रहेगा रूट है मिस्टर मलिक Ishujit Malik Mr. V. Malik for the petitioner Mr. AGA for the state opposite party 1 and 2. The Lord Council for the petitioner after the arguing for some time, after advancing arguments, seeks adjournment to obtain instruction. And also to amend the prayer, and also seeks leave to amend the prayer and the petition, which are advised. Matter is agenda. Item 11. What are the other than service? Yes. This is item number 12. 11. It's a tripartite or with a tripartite for the petition. Mr. AGA for the operating party number 1 and 3, 1, 3, and 3 and 4. 1, 3 and 4 is submitted by the counsel for the petitioner. The matter pertains to the subject matter of the petition, pertains to service matter, and it's not an assignment of this bench. The petitioner shall have the liberty to move the appropriate assigned bench during vacation.
Item 12.
Yes, please. Yes, please.
So that I report this other two and launching of the plan, the order of class in after the so that they happy.
Yes.
The problem the process of law should not be evicted from the land in court.
Yes.
Here I will submit that the land, the petition, the matter of the petition was possessing the land, that is why the revenue record in possession has also been broken. Other annexure one.
Yes.
So that order was passed by the Honorable Court. The municipality, here one of the grievance is taken the municipality to Karimda municipality.
Yes.
And the municipality issued the notice, the lords will get at page 31, 32. Thereafter, I filed the objection because they have already initiated a OP case against me, that is case number 7 of 2014. The lords will get
Yes.
at page 33, my shoulder.
Yes.
So was I filed.
Yes.
Thereafter, I was noticed under annexure 7 for hearing of the show. On that
Yes.
date, the hearing was not concluded because the executive officer was preoccupied in the other one.
Yes.
Thereafter, my lord, without disposing of that petition, all of a sudden they demolished the photograph I have given. They demolished a portion of the structure. My structure which is long. Now, my lord, they are trying to make construction over the same, construction of a road, and that is the instance of the local.
Could be. But you on your own showing you admit that it's a government land and municipality is constructing road.
Municipality is constructing the road.
So can it be legal ground? Cannot be.
Because
Maybe at the instance of some vested interest or maybe a person opposing you. But construction of a road by municipality at any government land or even private land. Because by definition, the municipal act makes barandas also part of the road.
taking into consideration that fact, my lord, this sort of court.
Anyway, you take notice, notice and admission. Mr. Devendra Lenkar for the petitioner, Mr. AGA for the opposite party. 1, 2, 3, and 5. It is submitted by the learned counsel for the petitioner that pursuant to the order dated 18/11/2022 passed by this court in WPC number 31098 of 2022. Observing that due process should be followed before eviction of the petitioner who is in possession of a government land. Government is in possession of a government land since law. OPP case number 33 of
7 of 14.
OPP case number 7 of 2023 has been initiated against the petitioner, in which he has filed his show cause annexed to this petition marked as annexure 6. Stop in continuation. the opposite parties, particularly OP number 4, Baripada Municipal Corporation, municipality. The opposite party authorities of Baripada municipality into bracket OP4 have taken steps and demolished part of the structure situated over the land under occupation of the petitioners. That is a plural group. Plural. But issue notice and admission indicating that the matter is likely to be disposed of at the stage of admission. How many extra copies? 2. ଆପଣଙ୍କ ମାଇକ୍ରୋଫୋନ କାମ କରୁଛି ମାଇକ୍ରୋଫୋନଟା ସ୍ୱର କଥା ଅଛି yes one extra copy one extra copy shall be served on the learned AG appearing on behalf since the Yago to the AG appears on behalf of the opposite parties 1, 2, 3 and 5 let an extra copy be served on the AG within 3 days, within 3 working days, to enable him to obtain instruction and file response of the opposite parties, of the state opposite parties. Appears and waives of notice and waives notice. Well, no problem, waives notice. So notice to the opposite party number 4 by registered court from the speed post. Requisites for issuance of notice be filed within 3 working days. Yes. I elect to issue notice as above. The learned AG appears on behalf of so and so. That is elected. Opposite parties 1, 2, 3, and 5 in waves of notice. Notice to OP number 4 by registered post with registered post of the speed post with AD as above. Status quo as a date pertaining to. So that is against the petitioner, sir. Obviously, status quo as a date means it is also against the petition. Pertaining to कौन खाता प्लॉट
Plot number 51.
5 है actually
Sorry, 5.
yes.
Actually.
Pertaining to acre 0.0700 decimals of HAL plot number 501 लिखिए under HAL खाता number 242 of Moja Devarasan, unit number 7 of Baripada town, district Mayurabad, shall be maintained till the next date. The opposite parties shall have the liberty to file the petition for variation of the order. List of when do you want to select? This I got a date row. Date row. Status code as well, date row. Good man. List in the week commencing 1 July 2024 before the assigned date. Yes.
13.
एक्शन जारी आनुचंती ना ताको आजल एग्रा की कोड लिस्ट करछु नहीं ठीक अछि आपन नाटा से पावर मिस्टर एसएस दास फॉर द पिटिशनर मिस मिश्रा यू आर देयर कितने जज 13 13 रे के Staging for the state. Which part is 1, 2, and 4. The learning counsel for the petitioner seeks accommodation due to non-availability of the applicant counsel. As paid for just for according to as paid for the counsel. As paid for liberty granted to move the vacation bench. The vacation for it is good. Move the vacation bench. See the date because in a more assignment. I cannot fix a date for another bench. Sooner.
Patel,
Yes, please.
Petitioner. Don't stop.
Mr. S. Rathod of the petitioner. Yes, yes, please carry on.
They are carrying on their business. One of the right here Gram Panchayat with the RL by other team, small problem from 2000, and subsequently there.
Mr. Rathod, to copy it, sir, can you this could decide where the hostel will be situated at your instance?
Not the
You have a just stand in front of your prayer.
they are
You have a right of rehabilitation.
Yeah.
You pursue that. Pursue that. You should. I mean, in all fairness, you have to pursue that right.
they have approved the authorities with the intention that
You can read the prayer.
and not only to dispose of the repentant.
No, I think it is prayer. Can you read the prayer?
Nature of only my repentation is.
So we can recap it. Recap it the first round, Mr. will take that. The court lack jurisdiction, complete lack of jurisdiction, and
That is the surprise.
non-application of mine and whatever, like Mr. Acharya said, or Mr. House submission.
Decision of the Gram Panchayat.
What lecture final decision on reputation filed by them shifting proposed new bus stand.
They take a decision, I don't only on.
The new bus stand I was appearing in PIL. Progressed a lot. You know why it was situated? It is situated, right? It's Netaji. That was across the river. So I was appearing in that prayer, so I struggled a lot. So for measurement, construction of boundary, everything, all that, so it happened. But ultimately, since they say that I mean, why I said is because the policy is the bus stand being shifted to another place creates difficulty for the commuter. They ultimately it has been made inside the city.
Nowadays, the new bus stands are constructed outside of the city.
So, but why this was constructed? When the land was identified, it has been the wall has been constructed, made encroachment free, and it's a good project also. And some new proposed bridges were to be constructed. That could not work out. So this is the difficulty in taking up a PI.
Similar petition of after the RTO. They provided the government, they provided the Tahsildar to demarcate the land.
Because I can direct this. 3 is a PI shifting of hostel. I do not have the roster assignment line. Second part also that cannot be done. And you should have, I don't know, experienced counsel like you should have asked them that they should pursue rehabilitation. Because in day out, whoever has said who were doing business in Boston, they are approaching this court. With a grievance that their grievance of resettlement is not being taken care of.
That was not in the final age.
And you should pursue. You should pursue. You want to withdraw this with liberty. No, unless you say that not place. I observe that you want to pursue your right of rehabilitation under the necessary statute. Mr. Ratha, for the petitioner, Sambit Ratha. So Sambit Ratha for the petitioner.
Along with Mr. Sahoo.
Mr. R.K. Sahoo, along with Mr. R.K. Sahoo for the petitioner. Samapika, Mr. Arson, standing counsel. for the opposite parties. 1 to 5. Mr. Behra is there. Prabhakar Behra, who is appearing for transfer? If he is available, then just ask him to give a seat. Because in his absence, I cannot mark his presence. If he is available. वो कोई ना कोई तो नहीं आएगा. The Honorable Counsel for the petitioner submits that the petitioners are earning their livelihood by doing business are only where earning their livelihood by doing business in the Boston are right here in the district of Andamar. He submitted that the Boston is operated by the regional the transport authority oblique OSRTC and which has been shifted to another place, thereby causing difficulty for the petitioners.
New bus stand is proposed to be constructed in that.
Which is proposed to be shifted to another place. Submission. Yes. Shifted oblique modernized, thereby affecting the petitioner's right to livelihood. The petitioners, it is submitted continuously. It is submitted that the petitioners shall move the appropriate authority for enforcing their for enforcing the right of better one enforcing the right of resettlement rehabilitation. And the writ petition may be disposed of. Ms. Mishra, the ASC, submits that the Boston has already been modernized. The proposal has already been made for modernization with shifting of the Boston. However, there is no dispute at the bar that petitioners can move their grievance before the appropriate authority regarding their right of resettlement or rehabilitation. In view of the submission made at the bar, the writ petition is disposed of, granting liberty to the petitioner to move the appropriate authority for rehabilitation of the resettlement in accordance with law. Yes.
Item 15,
Item 15, Tapan Kumar Mandal for the petition. Yes. State the bend problem. No, if a status code is to be taken, then I can't dispose it of. It has to be, it has to be again listed. You have to give a returnable date. I am not disposing of. So, Monter, became under Mustafa under for the petitioner. Mr. Sama became Mr. Additional Study Counsel for the state. The opposite party. 1 and 2. So I am issuing notice. If you want that, I am issuing notice. The counsel for the petitioner submits that the petitioner is a landless person. Petitioner is a landless, homesteadless person in occupation of government land. Government and railway land. Government land, which has also been converted subsequently to railway land. The petitioner seeks, petitioner apprehends imminent dislocation due to action of the opposite parties. And in the summer season, she has no other shelter to be accommodated and prays for interference of this court. So notice of admission. The learned AC appears for OP number 1 and 2, waves of notice. Let one extra copy be served at the learned AC within 3 working days. So notice to opposite parties 2, 3 and 4 by registered post of the speed post. Fixing early returnable date. Requisites for issuance of notice will file within 5 working days. I 6505 of 2024. Issue notice as above. The learned AC appears on behalf of 1 and 2, waves of notice. Notice to opposite parties will answer the repeat question by speed post with the stored post. Requisites will file accept one set of process fee. In the interim, it is directed that status quo as a date shall be maintained. The next date of listing. List in the week commencing 1st of July 2024 before the assigned date. Yes. Okay. Yes, I mean like, because I mentioned in the other to speed up. I two खाता को उपलब्ध हो तो वाले ही परिवर्तन. First item the status quo with respect to by the petitioner as well as the opposite parties. Upon which period. Status quo by the opposite parties as well as the petitioner. Pertaining to khata number 4, plot number 11 Moja put it down. Put it yes.
16.
Yes, Mr. Sahoo.
Yes. And challenging the
Yes.
wherein the letter from district magistrate directed to the petitioner. They state
It has to be listed along with that other order. You have to challenge that. If you read court order, maybe by a division bench, I don't know, or maybe a single bench. Unless or you take notice now and let it be listed along with that. Whatever.
You kindly see the given by Hon'Ble in earlier.
Yes. By now you must have realized that I have seen that.
No, many times.
Yes, yes, and there. Para 7. Yes.
From the record and after direction with the district agriculture officer Balangir district that an appropriate compensation package shall be recommended by the district agriculture officer Balangir concerning the general productivity of the land along with subsequent crop like vegetables and other property that land in favor of the petitioner. Accordingly, the district agriculture officer Balangir is directed to recommend an appropriate compensation in favor of the petitioner to the appropriate authority, not that directed me to give the appropriate authority
Here now, as project component ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି, then you have to make a state cut submission that the project component is not to pay the compensation.
And here you also my other is the why the proprietor of the stone crusher.
Fine.
In the year 2009, the stone crusher was established. That was running up to the year 2018. And since 2018, the crusher is not functioning in us. In the year 2020, the proprietor had sold the crusher along with land to another person. I have another secretary person. And I am the son of proprietor units. And since 2020, entire established has been already abolished units. And the present it has been filed in the year 2023. And you know, if time established, no notice was issued in previous read application to me. You know, you can verify the computer.
I understand. But the order doesn't disclose.
I know.
That I understand. But if you submit that the project
protect me, your lordship, and then protect me.
No, you see, because I may protect you, but it's a
Lordship, directly anything to do, your lordship, I would do much protect me.
it is kind of a money degree. And you see,
Repeat not my name, your lordship.
the crosser was operating from 2009 to 2018, my correct to you. The said plot belongs to the crosser, which much prior to 2009.
Yes, your lordship.
So it is not that the crosser was not impacting his paddy field. Rather you have got a reprieve. Because from 2009 to 2018, every year his crop gets damaged. So now say that
Verification without verification, no permission, we do that. Enough verification, permission we have room. So findings are.
that cannot be presumed. That there was, you see, then I have to arrive at a conclusion that there is no verification. That is not the stage now. And from the tenor of the order by the court, the court was prima facie satisfied that there is some the person is impacted. And whatever the collector has done, only that followed that or implemented.
Or else action as the proper will be taken against the other. Protect me and direct.
See, no, because I may protect you, but what you are saying that you are not liable, perhaps is not correct. Because from 9 to 18, who is liable? You are liable.
May be liable, but
Anyway.
telling me, without noticing me, and without obtaining instruction from the official, how
The paper was like item 16. So Sahoo for the petitioner. Samapika Mr. Additional Standing Counsel. For opposite parties 1 to 4. The petitioner is agreed by the order passed by the opposite party number 2, Collector Subarnapur, dated 17/11/2023. 17/11 to know 18.
18/5/2024.
18/5/2024. 18/5 into bracket annex 4. Purportedly the said order. Let us stop. Purportedly the said order dated 18/5/2024 has been passed pursuant to the order passed by this court dated so and so in WPC number 11020 of 2023. By the said order, the collector has directed the petitioner to take steps for payment of compensation amount to Sri Hon'Ble of village Sargaj for functioning of the stone crusher near the agricultural land public field of the claimant Sri Mishra pursuant to a report of the district agriculture officer. Calculating the compensation package of rupees 3,01,765. In continuation, it is submitted by Sapara. It is submitted by the Government Council for the petitioner that in the proceeding that has been referred to by the collector, report of district agriculture officer, or any proceeding before the collector, the petitioner has not been noticed nor had any opportunity to present his response to the claim of the claimant Sri Mishra. It is further submitted that the crusher was owned by father of the petitioner, who has passed away since
12/9/2020.
Since 12/9/2020. 2020. The crusher unit was sold to the present owner on
Another person.
yes, owner sale. The crusher unit was sold to its present owner on 7/8/2020, and in any event, the father of the petitioner stopped functioning of the crusher in the year 2018. Third, you should notice the learned ASC appears on behalf of opposite parties 1/024 and waives of notice. You should notice to opposite party number 5 by registered post with AD. For extra copy that 5 by registered post with AD. Requisites for issuance of notice will be filed within 5 working days. I 7327 of 2024. You should notice as above. AC appears on behalf of so and so. You have to say it. OP file to say it. In the interim, it is directed that no coercive actions have been taken against the petitioner pursuant to the notice number 4063 dated 18/5/2024 passed by the collector number 2 into bracket annexure 4. Please. No, the problem is that order doesn't direct payment by him, as he says. So obviously, then he may not be agreed by that also. But his problem is that he's not heard. His problem is that he's not heard. So the court never directed not to hear it. So make it be listed with that. But the consequence is that you are asking him to pay 3,01,000. And without hearing him, he doesn't know what has happened. Who is the owner, he do not know. Crop loss is one part. He very fairly says that it may be directed to the present owner or maybe other scheme or item. At least the collector's order should have reflected that. Whereas the inquiry was conducted, collector has doesn't also has not undertaken any proceeding. If you read the collector's order, there is no proceeding. He simply refers to the order of the this agriculture officer. Because agriculture officer has could have identified the crop loss or how the crop is impacted. But who is liable to pay? What is the determination? Nothing. I am holding that email. Just read that. I am looking at that email. Yes. Yes. Has calculated. Calculate the compensation. Where is the proceeding? Absolutely. Absolutely. At least he must know what has happened. And now the problem is that this fellow, when the order was passed, is not the owner even. That's a glaring mistake. So let them come. Let them come because this you have to consider the OP5 also. Because then OP5 has to again run. If they instruct that this order can be remanded back, what are the next thing? It can be done. I think you will agree to that. What the London AC is saying, you will agree for remand. Let them respond to this. Yes, Mr. Sir, you want to say something? Exactly. They have to, because unless this court doesn't hear like the other matter, you are saying that I was not heard. I am not the owner. Okay. No court will actually something. Yes, yes. Till the next date. Till the next date, list in the week commencing 1 July 48. Because I am not assigned, because I don't know. I can fix a date, but this is an assignment of another place. That doesn't look nice. Yes, I have said till the next listing, list in the week commencing 1 July 2020. Next date of listing. In the next date of listing. Listing before the assignment in the week commencing 1 2024. Yes, next. There's already an order by this court. Hey, what is the present status upon that? The order sheet achi, up-to-date order sheet achi. In con back order plan. সেটা তো দেখিলে ওটা supervisory court exercising 227 power or 226 power. What's has to, I mean, the court has to be some credibility. Order কত দেও না তাহলে সেটা অ্যাপ্লাই করেন, সেটা চ্যালেঞ্জ করেন যে অর্ডার অ্যাপ্লাই করে দেও না কি সিস্টেম করে পেন্ডেন্সিতে দেন I মু আপন ডিসবিলিভ করুন. But there should be some basis of passing an order. We will continue or we will finish the list. Again. Then what should be like that? Then we can finish it. The council are available to check that. Mr. Gyanarajan Patnaik for the petitioner. Mr. Patnaik. Sorry. So Subhendu Kumar Naik, sorry, Subhendu Kumar Naik for the petitioner. Yes, Mr. You are there. कौन करेगा? अपन इंस्ट्रक्शन लेते ना डिस्पोज कर रहा. It is pending. So bottom status कौन किए substitute है ले किए ना है ले कौन है ची God only knows. He doesn't show any kind of order. मुझसे appearance नहीं थी वो कि चाहिए थी तो substitution नहीं थी बेटा pending नहीं है ना सीट में pending कर बेटा अपन बेसिक क्या करते हैं. The petitioner is agreed by the non-disposal of the consolidation division number 438 of 2006. Hide under section 47 into bracket 1 of the 37(1). आजकल सब भूल होना चाहिए. जी जाए वाला सब भूल. तो मुझे जल्दी पढ़ेंगे बाकी भूल होगा. Read number भूल order भूल चलती जगह. 37(1) of the OCH and PFL Act. Orissa consolidation of holding O capital C capital H and capital P capital F capital L Act 1972 for correction of records in respect of the case lab in possession of the petitioner. Stated to be in possession of the petitioner. The counsel for the petitioner submits that in view of the innocuous player made in the petition, the petition can be disposed of, directing the appropriate authority for disposal of the pending matter. The additional standing counsel submits that the present status of the matter regarding appearance of the parties, sufficiency of notice, etc., that would lead to disposal of the petition is not known, as not disclosed in the petition. Having had the learned counsel for the parties, the writ petition is disposed of, directing so and so to dispose of the pending CR, Consolidation Revision number 438 of 2006 under section 37 into bracket 1 of so and so Act within the period of 6 months from the date of communication of this order. If the matter is still pending and there is no other legal impediment for disposal of the matter, the writ petition stands disposed of.
18.
Yes. Yes. Your name, sir? Sorry, Mr. Pravit P.K. Rai on behalf of P.K. Rautrai, the petitioner. Ms. Samapika Mr. A.C. For the opposite party 1, 2, 3, 1 to 4. Yes. Who are the private opposite parties?
They are the person for that inclusive in the commitment that we use by the petitioner.
What is your happy to proceed in accordance with law for removal of encroachment of government land, if any. By following the procedure mandated under the statute and giving adequate opportunity of hearing to all the affected parties. Disposed of para. it is clarified that this court has not expressed any opinion regarding merits of the case and the contentions of the parties that may be raised in the proceeding. Dr. Dakishi? On chess, kata number 8. Plot number 84, kata number 30. Dakishi? Mo kotha subuni? Apono subichi?
Last line is
Nahi. Mu jane. That is how be patient. Notice how asantu kuhantu to be disposed of. But you opt for that. I would prefer that notice how se asantu kuhantu then you get out. Se order ta presence ho. ଆପଣ ଏଇ ଯୋଉ ଅର୍ଡର କଲେ କଣ ହବ ଏକ୍ସପର୍ଟ ଅର୍ଡର ହେଲେ ଆଜି ଦିଟା କେସ୍ ଆପଣ ଦେଖିଲେ ଗୋଟେ କଲେଜର କେସ୍ ଆଉ ଗୋଟେ ଆଉଟ ମେଟର they say that we have the bona fide occupants and we are being removed contempt exam that is difficult माने a court will pass a order without knowing the details that is the difficult obviously that it becomes so difficult actually. ଆପଣଙ୍କ ସବମିଶନରେ ଲେଖା ହେଇଛି କ୍ଲିୟର yes
In the latter one, the view is correct. But even if the person is staying in the roadside, not having the right time, please enter for that.
it has to be no
And in other ways,
the difficult part is that what I was trying to persuade both the lawyers that the electricity connection doesn't have a prescriptive right regarding right of possession right of easement somebody is having electricity possession he cannot take advantage if after you want any clarification the GRF order can be clarified by adding one line that's it that ends the litigation that is another aspect both the parties have filed around say 5-6 cases regarding electricity connection for nothing. And I'm sitting here, I cannot say I have to go that side, why these cases have been filed.
and the previous one, which was you had to command and was a provisional. So it's not after now the final first to verify that.
କିନ୍ତୁ ମିଷ୍ଟର ରାୟ କନଫିଡେଣ୍ଟଲି କହିଲେ ଦେବରଞ୍ଜନ ରାୟ ଆପଣଙ୍କ ଭଳିଆ ଏକ୍ସପିରିଏନ୍ସ ଆପଣ ଯେମିତି ଇଲେକ୍ଟ୍ରିସିଟି ଏକ୍ସପିରିଏନ୍ସ ସିଟ୍ ଏକ୍ସପିରିଏନ୍ସ
I thought that
ଆମ ଅପେକ୍ଷା ମିଷ୍ଟର ସିଭିଲ ଏକ୍ସପିରିଏନ୍ସ ଦୀପକ ପାଣି ଲେବର ଏକ୍ସପିରିଏନ୍ସ ମିଷ୍ଟର ତୁକେ ରାୟ ସବୁଥିରେ ଏକ୍ସପିରିଏନ୍ସ ଆଇ ଆମ୍ ଏଡୁକେଟେଡ୍ ବାଇ ଦ ବାର କଣ କରାଯିବ ତାପରେ ପିଟିସନର ଯେହେତୁ ସେମାନେ ମାନେ ସେ ରିଟ୍ ବାବଦରେ ଭାବିଛନ୍ତି ସେ ସେଟାକୁ ପ୍ରିପେୟାର ବି ହେଲେ ସେଥିରେ ସେ ଯୋଉ ରିଟ୍ କଲେ ସେଟା ବିକଜ ଇଟ୍ ଇଜ ଅଫ ମି ବିକଜ ଆଇ ରେଡ୍ ଇଟ୍ ଆଣ୍ଡ ଆଇ ଫାଉଣ୍ଡ ଆଉଟ୍ ଏଟା ଆପଣଙ୍କ ଜିଆରଏଫ ଥିଲା ସୋ ଆଇ ୱାଜ କରେକ୍ଟ ଦ୍ୟାଟ୍ ଇଟ୍ ଶୁଡ ଗो ଟୁ ଜିଆରଏଫ ଠିକ ଅଛି ସେଟା ଗୋଟେ ମଡୁଲେଟ କରିଦେଲେ ହବ ଦ୍ୟାଟ୍ ଠିକ ନାହିଁ ଆପେଲେଟ ଅଥରିଟି ସେ ଅର୍ଡରଟା କରିଦେବେ because I have not expressed any opinion on merits. See the appellate authority तक कुछ जिपे लेकिन जिपे appellate authority से order कर देंगे so ताकि मेजर hurdle के लिए 50% 3 लाख के 60 है हाँ so that has reduced to certain extent there which is little bit unusual but still they have reduced and they have that will avoid the law.
One of the access amount is there, let's cannot be reconnected. That is one thing. That is no access. That's one thing. What could be there? This is the normal access.
Disconnection है आपके पास फिर पहुंच गया ना
One of the several aspects of it.
तब ठीक है तब disconnection है और disconnection है
Disconnection is a deposit amount. Then there.
सेटा appellate authority पर कैसे करेंगे But one thing I asked him and he answered that it's already disconnected. Yes. Yes. What you are saying would be right. Obviously, সেটা মানে আপন সেটা that becomes a মানে you see lawyer stand advice. Then it has nothing. Don't fight it out. There is an order by the JRF. The JRF order remains unchallenged. Order is there. And the JRF order are not challenged by the High Court will set aside the order. And JRF order is not to be challenged before High Court. It has to go before the Ombudsman. କହିବି ସେଟା ସେ ସେଇଥିପାଇଁ ତ ସେଟା ସେ ଅଯୋଧ୍ୟାରେ ସେଟା ଗଲା 15 ମିନିଟ speaking court ହେଲେ ଟିକେ ଏଇଟା problem ରହୁଛି speaking court ହେଲେ when you start sharing your thoughts and ideas with the lawyer counsel they start reacting they don't think that I passed a simply innocuous order that ସେ ତାର copy ଦିଅ let them share the copy ଯଦି ସେ appeal କରିବେ then ମୋର notice ବି issue କରିବାର ନାହିଁ नोटिस ना इशू करते थे कौन रहते थे नोटिस इशू करते रिक्विजिट देखा हमने आस्था मासे पर क्या था पता थैंक यू नेक्स्ट
19
yes so क्या है मेरे को पिके साहब for the petition
project plan, the road was so.
ये क्या है अपना प्रयास उचित किया है
I'm personally helped by my immediate president is the operation has allowed the same vendor to execute sell it the road. Now they have executed sell it for allocation of the road. So what is not permissible.
अरे अपना पारा 1 रोमन 1 पढ़ो प्रेयर रोमन 1 पेज 7 এটা আমি একটা থার্ড পিটিশন পিআই পিটিশন থার্ড
using that my road data
ଆପଣ ପ୍ରେୟାର କରିବାରେ କଣ ମତେ ଅସୁବିଧା ଥିଲା ଆପଣ ତ ସେଠି କହିବେ ଯେ ମୋର କଣ ଏ ଅସୁବିଧା ଅଛି ଆପଣ ଆନେକ୍ସର ଫ୍ଲୋର ଦେଲେ ଦେଖନ୍ତୁ ପଢୁନା ପେଜ 40 ହଁ ଆପଣ ତାକୁ ଏଗେନ୍ଷ୍ଟ ସର୍ଭିସ ମ୍ୟାଟର ରେ ଆକ୍ସନ ନେବା ପାଇଁ ଚାହୁଁଛନ୍ତି सर्विस मैटर में पीआई के साथ मेंटेन है एबे लार्जर देन रेफर एच सुप्रीम कोर्ट कहछि नॉट मेंटेन वो केसेस आर फ्रॉम ओडिशा दुबई साहब और आपका मिश्रा नो आपण को डिमांड करना आपण तो आपण लेक्चर की जने को ना रे से भल कोड होती ताके एक्शन लियो तो सिटी होते मोर जुरिडिक्शन कोड आस एटा आपण रिमांड किछि ना कोन कोन जा असुविधा है कि आपण रिकमेंडेशन देई थाते पढिछि से हेला तो इनफैक्ट रिलक्टेंटली आल्सो हैव डिस्पोज्ड ऑफ 2-3 पिटिशंस से आपण जो
I am personally with the people who are using that road data.
नहीं we the people पहला से कॉपी है ना
I am there personally have there picture is there.
ଆପଣଙ୍କର ପିଆଇଏଲ ର ରାସ୍ତାରେ କଣ ସେକ୍ରେଟାରୀ କଣଟା କରିବେ ସେକ୍ରେଟାରୀ ତ ତାର ନା ଜୁରିସଡିକ୍ସନ ଅଛି ନା ଅଥରିଟି ଅଛି ମୁଁ ଆପଣ କ୍ୱେଶ୍ଚନଟା ପଢନ୍ତୁ ଆପଣଙ୍କର ରାସ୍ତା କିଏ ମାଡି ବସିଛି ତହସିଲଦାର ସଫା କରିବେ ତାପରେ ସବ୍ କଲେକ୍ଟର ତାପରେ କଲେକ୍ଟର ରେଭିନ୍ୟୁ ସେକ୍ରେଟାରୀଙ୍କର କିଛି ଅଥରିଟି ଅଛି କିଛି ଧରନ୍ତୁ ରେଭିନ୍ୟୁ ସେକ୍ରେଟାରୀ ଅର୍ଡର ପାସ୍ କରେ ଇଲିଗାଲ ଅର୍ଡର ଆପଣ ଯଦି ସେଲ୍ ଲିଡ୍ ଆପଣ ସବୁ କହୁଛନ୍ତି ସେଟା ଆପଣ ଆଇଦର ୟୁ withdraw it definitely or you adjourn it.
That is also a provision of the Registration Act. Can approach the registering office.
ये सीधे ताकरा भी नहीं ताकरा पारा 2 रे जो देखिबे पेज 48 पारा 2 ही स्पीक्स ऑफ समथिंग एल्स आरसी कोन कहउछथि यू बी आर नॉट क्लियर मुझे पूरा बुझि पाले बट द नेचर ऑफ द क्लियर काइंड ऑफ थिंग ये ताकरा अगेंस्ट एक्शन ना ଆପଣଙ୍କର if you read the subject matter illegal nefarious activities and violation of government order by so and so sub register तार कोन ଅଛି ଆପଣ ଯଦି डिमांड्स ଅଛି ଯେ एक ऑपरेशन କରିବା ପାଇଁ ତ होगा କଥା ଆପଣ अप्लाई करू तो लाना कासे फॉर द पिटिशन ଆପଣ एक्सेस एनी So, Mr. Rai for the, on behalf of so for the petitioner. Mr. Mahanti, additional standing counsel for the opposite parties. One, all opposite parties. Therefore, for personally name करना है, that is another defect. जहाँ नारे complaint दीजिए ना party में, opposite parties. The Lord counsel for the petitioner after advancing arguments seeks for adjournment to obtain instruction. The matter stands adjourned. Yes, next please.
20,
Your name, sir? Mr. Kirtan Badai for the petitioner. Mr. Mahanti, additional standing counsel for the opposite parties. For list of the लिखी होती है, government counsel के नाम पे अपन लिखो for the opposite parties. Mr. B.K. Mahanti, B.K. Mahanti, Devendra Kumar Mahanti. For the opposite parties. The Lord counsel for the petitioner seeks accommodation to advance arguments to obtain instruction and advance arguments. The matter stands adjourned. Yes.
item 21,
Okay, but इतना अपन execution फाइल करते हैं कौन डिटेल्स अच्छी पॉइंट पहले 80 के डीड execution के पेंडिंग है right sir. So now in that execution whatever order will be passed it will be agreed by that. So you see the prayer here, it is also a nature of execution, not maintainable. Who provision CPC रे अछि जे गोटे एग्जीक्यूशन फाइल करिवे एग्जीक्यूटिव कोर्ट रे आ गोटे फाइल करिवे हाई कोर्ट रे बा अपीलेट कोर्ट रे हाई कोर्ट नो अपीलेट कोर्ट सर सेटा no I understand sir, I understand they are the court has to consider and pass an order. So where is that? How can I presume? I cannot presume. You see, then I have to. Judicial officers I cannot presume. I can say that even that is not partly correct. The collector is not acting, Tahsildar is not acting, no hurt. But judicial officer, how can I presume when it is pending? And you are coming during vacation. No. So you make a appropriate prayer if somebody is granted time to make a prayer for cost, make a prayer for striking up of pleadings. So those details are not there. Those details are not there. This can be presumed in a judicial proceeding. Yes. Sir, is it unusual to grant time one in March 24 and April 24? You see, I can only record your submission and observe that the Lord court will take a decision accordingly. But I can direct by presuming that it is not been taken. No. That is not done. That is not done like one of the counsel saying that by only looking at the other side I am considering the case. You see, a judicial officer is bound to pass an order in writing. That is the reason. After, sir, that point is well taken. That is why I am saying that why you have filed a petition and why you are doing execution or what happened. You are fairly stating that execution is pending. And how can you presume that what order will be passed, so and so order will not be passed? And always Mr. Counsel, always try to act in the best interest of your client. This order, if I am observing, that becomes so vulnerable. Because there is nothing. You are filed execution, it is pending. You are presuming so many things. And I have to pass a judicial order. Now, 3-4 पर किसी नहीं. 3-4 पर किसी नहीं. Suppose that is the reason I am telling that I can observe that. Case chair में what else? हाँ, तापर किसी नहीं. Sir, you see, I have seen several orders. You must have seen. Courts are directing for attachment, courts are directing for deduction. So what is so big deal about it? Unless you are agreed by an order. I understand, sir, if it is not directed in time, the area or maintenance is directed to be paid in three, sir, the first case. Mr. P.K. Chan's case. Area maintenance is directed to be paid in 3 installments. Why it is directed? The reason being it is kept pending from the date of filing. So there, on basis of presumption, I cannot pass it. If you want, I can observe on merits and say that I can presume things, or I am directed and you will book the appropriate court for necessary order. It is your concern and record your concern. How can you presume that? You see, the family courts board is hideous. Somebody coming to High Court will have direct. Then what about the other lady? Other lady which much more oppressed and destitute than you. Can you listen? There are so many destitute ladies who are much more oppressed than you. At least you see, no, somebody coming to High Court, it doesn't say that the person is more desperate. No, that's not the way to do things. That concern I have told you right that your concern I record your concern and direct that it may be treated in accordance with daily accordance with law. The petition and disposed of expedition that possible. That much I will do. Yes, anything to say? No, I understand. But obviously, general discussion. Time frame, please forgive me the reason I told you. More desperate ladies who is facing the same situation not coming to High Court. What can I say? So obviously I am expressing your concern. I mean, record your concern. This is item
21.
You are Mr. Maharana. Mr. Ajay Kumar Maharana for the petitioner. The petitioner lady the petitioner has filed the present petition seeking a direction for disposal of the C.P. execution case number 28 of 2023. Being the decree holder of CP, being the CP number, if you want to get it. (809) of 2019. ठीक होची तो अपन लेकिन आगे ठीक है अपन पहला को सुबुनी अपन माइक्रोफोन बहुत दूर पड़े छे और नंबरटा में पूछी ठीक पूछी ना नहीं पहुंचा छे पूरा included also the grievance raised by the petitioner is that the petitioner's execution case is kept pending. She being aged about 57 years, is suffering a lot as the judgment debtor, husband of the petitioner, is not honoring the decree. In view of the pendency of the civil execution case number 28 of 2023, under Order 21, Rule 10 and 11 into bracket 2 of CPC before the Judge Hon'Ble Court, this court is not inclined to entertain the petition at this stage. The learned counsel for the petitioner expresses concern that from the order sheet of the said CE 28 of 2023 as annexed to the petition, that is order stated 1/3/2024, 3/4/2024, 23/4/2024. It would be evident that the petitioner, the opposite party judgment debtor is seeking repeated adjournments. Seeking adjournments for which there may be a direction to the court to deal them to dispose of the matter expeditiously. Having heard the learned counsel for the petitioner without expressing any opinion on the merits of the case, as well as the rival contentions raised in the civil execution case, the petition is the writ petition is disposed of, observing that the learned judge family court shall do well to consider the grievance of the petitioner and deal with the case as expeditiously as possible. Disposed of amendment. Yes.
Item 22.
Who vacancy? Aged about 57 years. Our total is alien and is aged about 57 years and is alien. Yes, with the person in apprenticeship law of the yes. Period markers. I don't know. Tribunal, especially lower courts, the audio. And you must have, to some extent, have been consistent. Unless there is a glaring thing about the order sector, 4 months about the order sector. 4 months in that date age. And I understand, could be. Apart vacation, some difficulty. I understand.
Item 22.
Yes. Police in action. Instruction you. This is item Mr. Hon'Ble Patnaik for the petitioner. So Mohanty AC for the state. The petitioner in the petition alleges inaction on part of the police. Public direction for proper investigation. The Lord AAC shall obtain instruction in the matter from the appropriate investigating agency. List after mediation. List before the assigned bench after mediation. Yes. Yes, next please.
Item 23.
Yes. So Kaliprasad Mohanty for the petition. Kripaya appointment Mr. Mohanty को दिया है. पढ़े लेंगे. Mr. Mishra पढ़े ले. Mohanty versus Mohanty. Miss Mishra. Mr. The petition says same order. Yes. Instruction new. आपको छाड़ी वाले वो छाड़ी आपको छोड़ते हैं ना वो छाड़ी प्रोसेसर नहीं होता जमा छाड़ी वाले है तो दाता देखो आइटम 23 अपन सीआरपी स्टडी देखी देवे नेक्स्ट बाय नेक्स्ट टाइम does SP has power for investigation देखिए भारतीय न्याय संहिता मतलब कहाँ ଅଛି ସେଟା who has power for investigation ସେଟା ଦେଖିଦେବେ ମୁଁ ସେଥିପାଇଁ ଭାବିଛି କି କରେ ନହେଲେ ଆପଣ ହସିବେ ସିଆରପିସି ସେ କଣ କରୁଥିଲେ ସେ ସିଆରପିସି ଜାଣିନାହାନ୍ତି କୋର୍ଟ ଆପଏଣ୍ଟେଡ ହେଇପାରିବ SIT ହେଇପାରିବ କୋର୍ଟ ଆପଏଣ୍ଟେଡ ହେଇପାରିବ that's a different thing but CRPC provides power to SHO station house officer station house officer ଆପଣ ଯାହାକୁ ଇନ୍ସପେକ୍ଟର କହୁଛନ୍ତି IIC ତାଙ୍କର ପାୱାର ଅଛି ସେ କାହାକୁ ଦେବେ କଣ କରିବେ ନାଇଁ ତାକୁ ଛାଡ଼ିବାନି ତାକୁ ଛାଡ଼ି କେପି ମହାନ୍ତି ଫର ଦ ପିଟିସନର So Mahanti ASC for the again Kali Prasad Man Kali Prasad Man Mr. block DK Man Devendra Kumar Mahanti additional standing counsel for the dictate collaboration not a strike Devendra Kumar Mahanti additional standing counsel for the state then अपन वो colleague थे सर वो अपन को बाहर रखते थे when did I say आप वो कुछ कॉल जे मिस्टर देवरंजन राय अपन ने इलेक्ट्रिसिटी स्टॉल वाट along with Mr. ये अपन so Naik he was senior unfortunately he passed away I know that you ask
I know that I know you are involved in that case
very unfortunate से तुम्हारा सिचुएशन क्या है देख ला उसको टर्न पड़िले माने टर्न पड़िले किछि नहीं ताको केस रे तो I verified he was admitted where the pulmonologist is a regularly supervised ventilator was given new latest model ventilator there that is how recovered you realize that he talked every day that day morning also he called but suddenly very sad nobody expected it was जो हला second wave रे people much younger also दिल्ली रे तो अवस्था सोचे और जेते बेले जहाँ देखिबे it is always telling the effect they must redictate course ମୁଁ जो कहली कि आपण मान इंटरेस्ट करते there is lot of difficult आपण बुझी पारे कोन ता पर हम से कोड का दे लिखा
45
जोड़ा तो एफआईआर अछि भारती जोड़ा डेट कर देला in this in the week commencing
after July
हां 1 जुलाई 2024 जेतटा एफआईआर अछि 1 जुलाई को समस्त को कहले बुझले
आगे
inaction उतरे अछि 1 जुलाई in the week commencing before the assignment yes next
I am on VC, my lord. I am XP. I am not well, my lord. I am on VC, my lord.
there no matter can be taken
My lord, yes.
28
My lord, your lordship. My lord,
just one second your colleague is at in the court yes item 27 kindly speak to the microphone
my lord, my matter is 28, my lord.
but there is an earlier order right that order cannot be modified is that
trying to demolish my house and
it doesn't look nice ଆପଣ ସେଇ ଟ୍ରାଏଟା ସେଇ ଦିନ କରିକି ଯାହା ହେଲେ ନେଇଥାନ୍ତେ ଷ୍ଟାଟସ୍ को ଯଦି ଆପଣ ଚାହୁଁଥିଲେ ଆପଣ ଅର୍ଡରଟା ଟିକେ ଦେଖନ୍ତୁ ସେଟା ଗୋଟେ ଏକ୍ଜିକ୍ୟୁସନ ନା କେସ୍ ସୋ ଏକ୍ଜିକ୍ୟୁସନ କେସ୍ ରେ କଣ Yes,
What happened? The original recorded similar that property belongs to joint family.
yes,
And this petitioner is one of the co-sharer in the joint. But the appointment member stated, who is claiming to be the daughter of one Sadhar, is died issueless, having no man, and the subsequent.
first of all, if order is executable or not, what will see?
Yes.
The order which is executable, that is challenged or not, or that is final. Beyond that, executing court cannot do anything. Now, let us assume execution proceeding is challenging High Court. What the High Court will do? Again, the executing court cannot go beyond the decree. That is the basic mundane, yes. So, the ordinary bench has passed an order.
Once that order has been expert order, that has came to the knowledge of this petitioner.
You find setting as an expert
Yes, I have already filed. That is
pending where?
before the action and decision to valid. Under action. And this honorable court also stated this matter earlier in CFP number 107 of.
That is the reason, sir. That is the reason. No more there is any stay. And the coordinate bench has passed an order directing you to produce the entire order sheet. So how can we go behind that order? I cannot. You simply adjourn it, that is the best way. Yes.
Once the executing court, we have produced all those documents and that has been rejected. But
Sir, the difficulty is that I cannot
I
go behind the order passed by coordinate bench. I cannot. I should not also. In a way, I can say that I should not. Already the matter was taken up. Whatever prayer you could have made that prayer. And you see, the court has fixed a specific date.
And then during that day, or
And
that day,
Mr. Mondal, let me tell you one thing also.
I will be protected.
No,
Once
Mr. Mondal, you must also understand. These matters are not to be listed. It is not to be listed. It is because of me it is being listed. Because registry cannot list this matter. You must realize. So that doesn't look nice. This matter was not to be listed, but since they asked me that there is a specific date and order, so only thing I said to that, yes, you listed in the before me, then I'll pass order if I like. But I have gone through the brief, that's not. And the order, 7-5 order, just see what is written. So at least today what you would have done? You would have obtained the entire order sheet and produced before me. Where is that? Obligé क्या से? जो केस का पूरा केस था है, सेटा लेटर डेट रे नंबर है कि obligé क्या से? Doesn't matter. There is confusion किसी नहीं. It doesn't matter. 2/23 ही पारे, से टाइपोग्राफी नहीं पारे, माउस को oblique रे पारे आगे टे. बेले कोटा रेकॉर्ड ट्रांसफर में. ट्रांसफर ले हुआ नंबर हो. तो सेटा रे किसी नहीं. That is confusion छाड़ना. और सीट का एक कोड है. वो पारे नहीं है. नहीं सीटा. कोड ही अच्छी. कोड रे और बने. कोड ब्रीफ रे क्या? ଆପଣଙ୍କ ଆଇଏ ଛଡା ଆପଣ ଦେଖନ୍ତୁ 7-5 ନୋଟିଂ ଅଛି ସେଇଟା ଏଠି ପ୍ରଡ୍ୟୁସ କଲେ କଣ ଫାଇଲ କର ଠିକ ଅଛି ତାହେଲେ ପ୍ରିପେୟାର ପୁଷେ ଯଦି ଆପଣ ପ୍ରଡ୍ୟୁସ କେବେ କରିଥିଲେ ଡେଟା କହିଲେ ମୁଁ ରେକର୍ଡ କରିଦେବି ଠିକ ଅଛି ତାହେଲେ ସେଇଟା ସେଇ ଡେଟରେ ଆସିବ 1900 ରେ ଆସିବ that I cannot that prayer you should have made though the matter was directed by the order though by order dated 7/5/2024 The matter was directed to be listed on 9th June 2024. 19 The matter has been listed, being moved by the petitioner by filing IA number. Again, IA number 653 of 2024. Appearance lecture. Okay, Mr. Mondal. Tapan Kumar Mondal for the petitioner. Mr. Mahanti, Devendra Kumar Mahanti, Additional Standing Counsel for opposite parties. IA order. IA order. IA. এখন ঠিক আছে মুই আই ডাকে দিই আই ঠিক আছে অপোজিট পার্টি 125
Procure that are you
relax 125 Mr. Mondal submits that the Lord's counsel for the petitioner submits that in obedience to the order dated 7/5/2024. He has filed the certified copy of the entire order sheet in execution case. ठीक है सर्टिफिकेट को एंटायर ऑर्डर जहां ऑर्डर शीट shall reproduce entire order sheet in execution case as directed by order dated 7/5/2024 by the court bench. The learned AC submits that copy of the IA has not been served the learned counsel for the petitioner submits that he is serving copy today in court. Serving the copy today in court. As directed, as directed, the IS has been listed along with the CLB on 19/2024 for consideration. It was assigned. Yes.
Okay. May I please your lordship? My lord, your lordship,
Yes.
after coming into the RERA Act,
Yes.
my much prior to that, my apartment was completed consisting of 789 flats.
Yes.
But on wrong advice, my lord, of the authority, I filed an application for registration of my project under section 3 of the RERA Act.
Yes.
And your lordship may now come to please page 18 annexure 2.
Yes.
This is my second application as per the new form. And in this form, I was directed to comply the defects along with filing of certified copy of the ROR.
Yes, Mr. Bhar, I mean,
My lord.
it's sorts of notice. But are you aware of the provision of refund of statutory deposit?
But because my application is not required to be registered. It is not
That
by
is why
by mistake, my lord, I had filed the application.
I have an appealable case. You have an appealable case. But
And no
is there any provision, I mean,
No, there is no provision, my lord. There is absolutely no provision.
Mr. Bansudhara back for the petitioner. And please ask your associate or you yourself to examine that aspect.
My
Because
lord.
this is a provision, they have to comply with that. I mean, they can't simply say no. But
My lord, what
there
has
is
happened, my
no provision.
my lord?
There has to be some mechanism. That's
My
your
lord.
part.
Yes.
So Bansudhara back for the petitioner, Mr. About that appeal for him. এটা খালি OP2 ବି ଯିବ ସେକ୍ରେଟାରୀ ଅଫ
ଆଜ୍ଞା ମୁଁ ସମସ୍ତଙ୍କୁ ନେଇଯିବି ଆଜ୍ଞା ସମସ୍ତଙ୍କୁ ଚାଲି ଯାଉ ନେଇଯିବି
ନାଇଁ ଆପଣଙ୍କର ଅଥରିଟି କୁ କାହିଁକି ଦବା ମାନେ ଆଡିଶନାଲ ସେକ୍ରେଟାରୀ
ଆଜ୍ଞା ଅଫ ଦି ଅଥରିଟି ଅଫ ଦୁଇ ଜଣଙ୍କୁ ନେଇଯିବି ଆଜ୍ଞା
କଣ ଲେଖେ petition it is submitted by the Honorable Counsel for the petitioner that you have been designated senior Mr. Bhatt in the
no my lord
that due to inadvertence and lack of understanding, certain amount was deposited before the Orissa Real Estate into bracket Regulation and Development ORERA an authority under the Real Estate into bracket Regulation and Development Act of 2016. Which came into force in the state of Odisha from 1/5/2016.
My lord, that section came in 1/5/2017, my lord. I have wrongly it is-
But the rules came into force with effect from the date of notification in Gazette on 25 February 2017. In continuous stop in continuation, it is submitted by the council that the amount deposited by the petitioner was supposed not to be deposited, not to have been deposited, but due to but due to what like that about the legal deposit question.
but due to the fact that my apartment was completed, project was completed much prior to the act came
And
into
the
force.
operation amount was deposited, which is not to be refunded as spread in the reputation. I issue notice to the opposite parties 1 and 2 by registered post of the speed post with heading requisites for issuance of notice within
By Monday, my lord. By Monday,
requisites will be filed within 3 working days
my lord.
in a returnable date list after SR.
Only I prefer no coercive action in the meantime, my lord.
There is a report upon against it. Upon report, course action upon it.
Nahi aga more application tilla to restore the application which is dismissed for
Right.
default.
इसलिए कोर्स इलेक्शन ही करेगा आप और कोई पोजीशन नहीं करेगा सीए प्रेयर करेगा ना वो कोर्स इलेक्शन
Notice जाओ क्या notice जाओ उनसे.
और एग्जीक्यूशन की क्लेम की अपना सूट मनी सूट कर पड़ेगा कौन मतलब
I understand.
I guess 7348 I will look to issue notice
One set of process.
क्या अपना करोड़ा रिजेक्ट कर ले कौन लेटर का
My lord, your lordship may kindly see annexure 7, the order of rejection.
Any action pursuant to the letter number 2496 dated 31/12/2020 issued by the opinion number 2 into bracket annexure 7 to the writ petition shall be subject to the result of the writ petition and shall abide by further orders passed in the present writ petition.
My lord, yes. Oblige, my lord. One set of process. My lord.
Pardon, my lord. Item 26.
Yes, thank you.
Item 25.
Master matter. Yes, Mr. Das.
My lord. Item 26, my lord. Minor.
25.
Sorry, sir.
None appears for the petitioner, though the matter is called twice over. Opposite party petitioner like none. Opposite party Mr. 25. Suman, you are there. Suman. None appears for the petitioner, though the matter is called twice over. The matter stands at. Yes.
26.
Mr. P.S. Parthasarathy Das for the
Yes.
petitioner, Mr. D.K. Mahanti, additional standing counsel for the state. Yes, Mr. Das.
My minor daughter of the informant, my lord, kidnapped since
The petitioner alleges inaction of the opposite party police authority, being unable to recover his minor daughter, who is missing since
16/5.
16/5/2024. The learned AC appears for the opposite parties, the state opposite parties, and waves of notice. Stop. The learned AC shall not get instructions in the matter, and the authorities shall make an all-out effort for recovery of the minor child and restoration of his custody to the legal guardian.
Right.
This term will be commencing.
Take all possible injury.
Yeah, say.
On 6, your
Commissioner,
on 6, your lordship, 6.
ନାଇଁ ଏଇଟା ଆପଣ ଶୁଣନ୍ତୁ ଆପଣ କଣ ହେଇଛି କି 16/5 4 ଦିନ ତଳେ ଏ ଘଟଣାଟା ଘଟିଛି ଆଜି କେତେ ହେଲା?
ସେମାନେ ତାଙ୍କୁ
10-12 ଦିନ ତଳେ ଘଟଣା ଘଟିଛି
ମାର
ତେଣୁ ସେଇଟାକୁ ନିଶ୍ଚିତ ୱିକ୍ କମେନ୍ସିଂ 18/6/2024 The additional standing council assures this court that police shall make all endeavor all possible endeavor for tracing out the missing child. Yes.
obliged.
Yes. How related?